Thank you for tuning in to the Starkey Multifamily Podcast. I have with me attorney Justin Smith. Justin, thanks for coming on.
My pleasure. Thanks, Reed, for having me along for this one.
I do want to say a disclaimer on here since we are going to be talking some legal topics. This is nothing in here is considered legal advice, and please seek legal counsel on any decisions you make based on this information. So with all that disclaimer out of the way, Justin, thanks for coming. Why don't you tell us a little bit about yourself?
Okay. I've been involved in landlord-tenant law really exclusively for 25 years, and it's really all that I do. I first got my feet wet with my in-law, with my father. He actually hired me. I used to joke that he was the only one that would actually hire me. But anyways, he and his practice had a municipal housing contract, and that's where I first started in landlord-tenant law. And from there, after about 25 years, it grew where I was involved with federal housing and HUD federally funded housing for at least 15 years. And my firm used to have more housing contracts in the federal scheme than any other lawyer in the state. I was quite proud of that. But then politics got involved, and I got a little bit tired of all that, and I started working with individualized investors, housing communities, property management, even mom and pop investors that have one or two houses. So I've enjoyed that area of practice, and it's really the only thing that I do right now. I don't so much have a practice that deals with a lot of the quiet title and some of the acquisitional aspects to real estate anymore, because I just have so much volume in landlord-tenant related issues that come up, which ultimately clearly can involve eviction cases. But the goal, of course, here, and I'm an investor myself, is to keep something productive. Where a relationship tends to look like it's not making sense anymore, obviously you have to end it. But if we can save it and live another day to see another paycheck, that's my goal as a counselor, not just an attorney. So that's what I've been doing for 25 years, and I'm fortunate in that I have a bunch of clients that I work well with, and whenever you select an attorney, that's all I have to say is make sure that it's a two-way good relationship. There's a lot of us out there, frankly.
Yeah, and I can say, just my own personal input that I did a lot of research before you and I started working together, and many investors in the Metro Detroit area brought you up as highly recommended. So
it's important, I think, just pragmatically. I mean, if you have a lawyer, I've administered housing management, and then I am an investor. So I've sat in your chair, Reed. I basically know the game. I know the real estate game because, I have money into it as well. I'm an investor. So thank you for that.
Yeah, so we'll start off with talking about the lease. So probably the most important document that there is for the landlord-tenant relationship. What's important in it? What are some things you see that are bad? And just give us some general advice about it.
All right. Well, the lease, as I actually gave a presentation about a week ago, and so this is a little bit fresh in my mind. The lease is the primary document. It defines the rights, duties, obligations between the tenants and the landlords. It can be for any period of time, frankly. It can be a month to month. It can be a year or two. For the residential setting, which is primarily what I do some commercial representation as well. But from the residential side of things, certain clauses are illegal in leases. Certain clauses can be stricken from leases by a judge. And it's all governed by a law called the Landlord-Tenant Relationships Act. I'm sorry, I have that wrong. That's the Security Deposit Law. The Truth in Renting Act is the law that defines what clauses you can have in a lease, what clauses you can't have in a lease. Now, I work with a lot of realtors, and oftentimes I see the realtor lease that is produced, nothing against our realtor friends, but the realtor lease is often a very neutral lease document because, frankly, I think that realtors, if they're in the business of trying to establish relationships between landlord and tenant and get people tenanted up, they want to provide a document that is kind of neutral and not too onerous upon a tenant. That can be problematic when it comes time to actually end a tenancy relationship if you have a lease that's too neutral. The lease document itself, as I said from the inception, it describes the rights, duties, obligations of everybody. I know that a common question that we get is what term should one have in a lease? It does depend on circumstances. as many things depend on circumstances, but I'm not a fan of more than a single year lease at all. Because even though the investor is thinking that they're tying someone up for more than a year's length of time, maybe you don't want to tie someone up for that period of time. And also you have to understand as an investor that even though you sign a long-term lease for more than a year, a tenant can skip out, as some of us older investors know, at any time. And there's very little repercussions that can come after a tenant if they skip out on a lease early. So I usually don't have renewal clauses in my leases, or I don't even say in my lease that a month-to-month tenancy will continue after expiration of the lease. And there's reasons for that. I don't want to bore everyone, but I'm not a big fan of long-term leases. If there is a tenant in particular that you're a little bit on the fence about with placement, I've had some people that choose to put them on a more limited 3-month lease, 6-month lease, month-to-month lease even. If the property is rough, for instance, and you know that it's rough and you're leasing to someone under the guise of this is an as-is property, oftentimes I have that set up as a month-to-month tenancy, because if you get a bad judge, when I say bad, I'm meaning a tenant-friendly judge. I can't criticize judges, but when you have a bad judge, I'll say it again, that is particularly landlord-tenant friendly, even though you have a lease document that says this is an as-is relationship, the house is rough, the tenant agrees to accept the house as being rough. If it turns out to be inhabitable, or if there's major things with plumbing or heating involved, the as-is clause is not going to help you. And so it's better that you have a shorter term lease rather than getting someone in there that makes a plea in front of a judge that this house is not really habitable because A, B, C, and D, and they might be a professional tenant, but they give a whole list of things and they go off to the city inspector and have the city inspector come out. That's exactly the type of situation that you don't want to be in, where you have them signed up for 2 years, because it's going to be hard to get them out. And now what you have is a judge that's telling you that you have to do all these thousands of dollars of repairs, you know, during the term of a long-term tenancy. I would prefer being in a situation, especially with questionable properties, to just be on a month-to-month or as limited a relationship in the lease as you can. I know that we had discussed perhaps talking about lease term. So that's kind of my spiel on all of that. I know that a lot of people put late fee provisions into the lease. This is a very common clause in a lease. I dealt with a client the other day, and he literally had $500 of late fees per month in the lease. Now that's clearly unenforceable.
Yeah.
It's one thing to have in your lease a provision that tries to encourage payment and payment on time, but it's another thing to have a crazy situation where you're accumulating $200 or more of late fees a month. Now, if you can get it and you don't have to go before court, great. You know, I mean, it's nice to get the extra income for a late fee, but once we go into the courtroom, if a judge sees, and it depends on the court, if a judge sees that the late fees are excessive, you might get a bullseye on your back the next time you're in court again. So late fees are a clause that you can clearly have in your lease. Many people do. And whether or not it's enforceable in the courtroom, we don't know until we know which courtroom we're going into, which judge we have. Another hot topic right now is, you know, with the influx of bed bugs, you know, pests, rats in South Oakland County in particular. Some people are putting into their leases now, and I have some of these lease clauses, where you offer the tenant an inspection period where they at their own expense can come in and the property is as is. It's been given to the tenant clean, but the tenant has an opportunity to actually do an inspection if they want to have an inspection, you know, and that inspection period has to occur within the 7 days prior to actually getting keys for the property. So that's a good way of avoiding situations where the tenant says, you know, the bed bugs were here or the rats were here. How come you're not taking care of them? So you can get around certain situations like that. And the professional type of tenant will play games like that. They'll hold back on what they perceive as defects or problems with the property until you start enforcing the rent that's due. Once you start serving them with notices, oftentimes the professional tenant will start bringing up issues like the faucet's dripping, or, you know, I have a respiratory problem because of mold in the basement. Usually you don't hear about things like that when you're shaking someone's hand for the first time doing a lease up. But the moment that the landlord, the investor, starts to enforce rent payments, that's sometimes when the professional tenant shows their feathers. So I have a tendency of going a little bit off topic. We're talking about lease provisions. That's one. Another lease provision that I started to work into leases is a clause that says that if you have two applicants with two separate incomes, and that is going to be the basis for granting someone a tenancy because their income with two people qualifies. What if one of them splits up in the relationship, okay, leaving basically one income left? You know, if that happens, then the investor is in a much more precarious situation moving forward from when there's a split. So I have a lease clause now that converts any term lease into a month-to-month tenancy if one of the co-applicants has left the property. Because what can happen is, in that situation, and I see this happen all the time, once one of the two people in a relationship leave, then the one that's remaining, the rent payments will start to slow up, and then you'll start to hear things about the quality of the housing is low, or there's problems with the housing, and they're just doing a survival measure. But basically what they're doing is they're giving you trouble. So I like to have clauses in my lease that protect and put the power back on me, the investor, the landlord, to make a decision about whether or not I want to move forward if one of the two parties that initially applied for the tenancy have split up. So that's another one. As I was preparing for our podcast today, Reed, I checked that one off as something that I wanted to talk about.
Okay, well, I'll kind of dig into some of those. I want to talk about that excessive rent you mentioned, the $500 a month in late fees. I think maybe just a comment, but on a legal side, of course, that's not legal, but I think on a just a greedy standpoint even, I don't think that it's effective to do too much, because if you get to the point where they can't pay you, then you've lost everything. So
That's right.
You want to have it reasonable. So, I mean, even you may think you're being greedy by asking for too much, but I think you're just throwing money away by asking for too much, because once you reach a point where they can't pay you, or they know that they can't, then you're not going to get another penny out of them.
That's right. And you know, all of this, some of this is style, some of this is just trying to make money, but at the same time being reasonable and nice to people as best you can, because ultimately if something happens, and sometimes bad things happen to good people and you can't control it. Other times you have professional tenants that are playing the game. But ultimately, whether or not we all get hot-headed with our tenants or make big time demands for $300 late fees and things like that, there will be an ending at some point to the landlord-tenant relationship. And we don't want to strain the situation so much where when the tenancy does end, that basically you have a trashed house, because people will build up resentments if you come off at times being way over the top with them. So, you know, maybe that parlays into, Reed, what you're saying a little bit, in that, you know, ultimately we want to make some money for ourselves, clearly, but we also want to provide a relationship with our tenants such that in a practical way that relationship continues on a good, respectful basis moving forward.
So you mentioned professional tenants as well. How do you identify them in the beginning so that you can prevent that, you know, in the end, and then also kind of throughout the relationship, how do you prevent it from becoming to where you have those tensions? So obviously there's a good screening, and then probably managing them politely, like you said, but what other things can somebody do?
You're first trying to select your tenant. I found that the tenant that doesn't have, for instance, like the security deposit money all right up front, okay? Let's say you're charging about a month or a month and a half for security deposit, and they start asking you to change your lease terms or change your requirements. This has happened to me a number of occasions when I've been doing lease ups. They actually go through my lease, and I do show them my lease because I want them to be informed. But the tenant that starts nitpicking your lease, complaining that the grace period is too short, or that the requirement for security deposit money is due up front before they even take the place. Those are the types of things where that you could be dealing with a problem tenant, a professional tenant. So if you get resistance and pushback, or even, we have to be careful with this one, but if you hear a tenant when they're talking to you, talking about how bad their last landlord was, don't assume that we as the landlords are going to be Prince Charming or Cinderella. They're probably going to treat you as a landlord perhaps similarly how they treated the last landlord. I mean, we have to assume that. We might all think that we're really good landlords, and that's not going to happen to us. But when a tenant starts talking to you, a prospect, about all the things that the previous landlord did incorrectly, then be afraid. You might want to think about someone else. Another thing about professional tenants is they often complain about the small stuff at the front end. They'll complain about the way the paint looks, the way that there's a blind that's hooked up that's a little bit crooked. For those that are complaining about the small stuff early on, you better make sure that you stay on top of that tenancy situation to make sure that all lines of communication for repair requests perhaps go through even a text or an email form. You can even put it in your lease that the official line of communication for tenant-related requests and repairs shall be by texting me at this number or by sending an email. That way, you can kind of have them document the whole history of interactions truly between landlord and tenant. And that will ultimately help you out if you have to prove that a tenant's being unreasonable. If you have an unlicensed property and you start leasing the property up, the professional tenant loves that situation because they don't tell you that they're going to cause you problems with calling the city on you, but they will call the city on you the second that you start asking for your rent money. Okay, so if you're in Detroit in particular, where there's a lot of substandard housing, and substandard housing is anywhere, you have to assume that each local municipality has their own licensing regulatory measures set up because they can make a lot of money off of it. Frankly, the cities do. So if you put someone in there before you have a full license, I know that a professional tenant's going to love that situation the moment that they don't pay rent and you start asking for rent by sending them a notice. And then lo and behold, they've known the whole time, as you do, that you haven't had a licensed property. That will basically put you in a situation where you're going to have a court battle, and the judges are not going to like you too much if they find out that the property was rented without a license. Professional tenants prey on unlicensed property owners.
Yeah, and I'll piggyback on that. I mean, I think, a lot of investors, you hear the negative relationships between the city for whether it's city inspection or rental inspection or whatever it is, but ultimately, when you break down some of the walls, that there's obviously tension there because they want you to repair stuff and you don't want to have the money or don't want to spend the money on it. But I think ultimately we're all looking for the same thing. We want to ensure that we have safe, habitable houses, at least the good investors for the tenants, or if we're selling them for the end buyer. And so I think we have the same goal. And I think when you break down past that, the licensing gives you that extra, hey, I've at least made this house habitable to this city's standards, and I've done my job to get everything there. So if it does go bad, you've got a lot of other people on your side that you can say, look, it's been signed off by third parties that don't have an investment in this house. So
yeah, that's right. And understand that the people that come in and do housing quality inspections for Section 8 departments, and also the municipal inspectors that license up a property at the inception of the landlord-tenant licensing procedure, they cover most of the habitability related issues. Okay, every little defect in a house that is not habitability related is not something that necessarily is going to hurt you in the courtroom. A lot of people don't understand that. If there is some bubbling in the paint, for instance, that no one noticed at the front end, and the tenant starts complaining about it, from the standpoint of landlord-tenant relations, sure, you might want to take care of it. But if a tenant is calling you all the time on stuff like that, not every little defect in the property is habitability related. And yeah, if you have that stamp of approval from the city or from the housing quality inspector, if you're working with Section 8 departments, then yeah, having that stamp of certification, this property passes, a good thing. And I actually have it in my lease that this property is in good condition. Well, actually, all of my properties are, maybe not the case for everyone, but I have it in my lease that this property has passed housing inspection and that it's being turned over in that condition. I'm working into my leases, as I said, the whole thing about giving them a right to inspect if they don't want it. They never do. You know, you put it in your lease. I mean, you put a lot of things, you put it in writing and they sign off on it. And I've never had one tenant that I know of that has actually done an actual inspection upon the landlord saying that the property is in good condition. But by putting it in the lease, it's yet another thing that if there's a challenge in court in the eviction phase, that you can always point to the document and say, hey, not only was the property inspected and approved by the city, not only was the house turned over to you in good condition, but you also signed off on it, and you had this ability, if you had any concerns at all before you even moved in here, on getting your own inspection. Now, I did have someone in one of my own properties, and I was surprised, but they did actually call in an HVAC person and made a complaint about the fact that my ducts seemed dirty and they had an asthma problem. So, you know, that put me into a situation, you know, to be very cautious and, you know, sure, spend the extra $200, you know, to eliminate that particular issue and then move on with it. Cities and their inspections, they'll make their money, they'll collect their $100 to $300 yearly or bi-yearly to get you inspected. And of course, we all can expect a follow-up inspection. Cities are making a lot of money, but ultimately, hopefully what they find is a property that doesn't have too many things that you need to take care of. I hear that that Centerline is kind of tough. I hear Roseville can be kind of tough. I know that Hazel Park used to have its issues with re-inspections and things like that, but I'm going a little bit far afield here.
That's okay. Yeah, in my own personal experience, I've found Warren to be pretty difficult.
Warren, I forgot about Warren too, right? That's almost the gold standard of difficulty. When I go in there on my landlord-tenant situation, there's this whole other side of the main floor that's dealing with code enforcement. And yeah, that's a pretty busy room. I think it's on Wednesdays that they do all of those code enforcements.
Yeah.
But with those, by the way, usually you get through those too. They write you a misdemeanor ticket, which can be frightful. All they want to see is to compel the person that's cited. First of all, they want you to pay the fine, but so long as you give them a reasonable compliance plan about taking care of the situation, you have the ticket written down to something less than a misdemeanor. It's still going to cost you about the same amount of money depending the city you're in. But yeah, Warren's pretty bad. You're right, Reed.
So let's talk about probably the juiciest part of the talk here, where I'm sure everybody is interested in. I definitely see the most questions that you end up answering through some Facebook groups and stuff.
Well, hopefully I make it juicy.
Yeah, well, I mean, I guess this could be a dry topic, but I know everybody's interested in it who's, you know, maybe managing their own properties or, right, you know, maybe some people that they're looking to buy properties, but it's the eviction process. So let's start with what reasons can you move to evict somebody? So there's the obvious of non-payment. There's habitability, which may be less known. Are there other reasons that that you may move to remove somebody from the property?
Parties, barking dogs, smoking weed or otherwise. We can cover that, by the way, with the changes in the recreational laws. You know, I get a lot of questions on this. Disabled cars in the driveway, wrecking the place. You can choose to initiate an eviction process primarily in one of two ways. One is financial, if they're not paying rent or utilities. Okay, that's started with a demand for possession notice. It's called a 7-day notice, and there's, you know, some tricks of that, but you can start with that. Or if you really want the tenants gone, You can start out with something called a notice to quit, which is a 30-day notice. And I'll explain the timing of 7-day versus 30 days in a moment. But a notice to quit involves really conduct breaches in the lease that are substantial and are not financially related. Okay, so notice to quit for non-payment of rent, 7-day notice. Almost everything else that is a substantial breach of the lease that does not have to do with paying money is a notice to quit, which is a 30-day notice. And I talked about some grounds that you might choose to list on a 30-day notice. Now, another grounds for a 30-day notice is if there is no lease, okay, or if the lease is over, the term is done, and then you can start it out with a notice to quit. And notice to quit, by the way, is a termination type of case where the tenant itself does not have a right to stay once you prove your case. The demand for possession, the 7-day notice, because they're not paying rent, that always gives the tenant the right to pay and stay.
Mm-hmm.
So I get a decent amount of clients. Most of them are newbies. And sometimes I don't do the best job maybe explaining all this, but they give me a demand for possession notice that they've already sent out to the tenant. And then the tenant doesn't pay, and they give the case to me and say, Smith, do your thing in eviction court. I want them gone. And I say, well, no, wait a minute. I just have to clarify this. You can't have someone gone necessarily if you sent out the 7-day demand for possession notice. The demand for possession notice gives the tenant always the right to pay what's claimed due and owings, even through the court process. So, you know, I get frequent flyers all the time where I'm dealing with non-payment of rent cases 3 times within a year's period. Very frustrating for the investor and for the landlord.
Mm-hmm.
They have to pay the lawyer and put food on my table instead of keeping it for their table. So you got to know your theory first. You got to know your goal. If your goal is to get rid of a tenant, you might have a problem with a demand for possession. You get into court quicker with a demand for possession because it's only a 7-day notice, okay? But once you're in court, it opens the door of habitability related issues, the faucet's dripping, mold problems, they're not doing the repairs. Even though it's all a bunch of garbage in your opinion, it still gives the tenant the right to dispute what you're charging for rent and what's due and owing. And it gives them a right to stay if they pay whatever the judge determines. So that's the difference between the 2 primary cases, demand for possession and termination based with the notice to quit. The notice to quit is a very important document because it's a 30-day notice. The worst news that I can give to someone that did their own 30-day notice is at the 30th day that they've waited out all this time, and I look at the notice and there's fundamental things that are incorrect about the notice. Okay, and then I have to give them the bad news of saying, hey, you know what, you can give the notice to me to redo and I'll get it right for you, but guess what, then we got to wait another 30 days.
I do want to jump in. So we didn't talk about this before, but the processes that we're talking about are specific to Michigan and maybe even more so Metro Detroit. But if you're in another state other than Michigan, some of these rules are going to be different.
There's no question about it. I had someone come to me and they were from Oregon, and basically what is our 7-day demand for possession notice in Oregon is a 3-day demand for possession notice, and they call it something else. I've kind of railed on this a little bit on some of the Facebook pages, but there's no such thing in Michigan called a notice to pay or quit. That is basically, if you start out with a document that looks like that, it's going to get probably kicked out in court if the tenant shows up with another attorney. So I swear I get that with new clients coming into me about 5 or 6 times a month. And every time I see it, I want to keep reminding people in the various Facebook investor groups to just make sure that you get the preliminary notice right if you're doing them yourselves. And it's much more of a problem if you get the 30-day notice to quit incorrect. But you're right, yeah, every state's different. A lot of the concepts are the same, and the timelines maybe work a little bit differently, but every state is very particular. I'm only licensed to practice law in Michigan. There's other attorneys that practice in various states. I only do it here. And I get some questions from my cousins in Ohio about a tenancy that they're involved in. And I'm kind of like, whoa, you know, all I can tell you in theory how I think this might work, but I'm not sure about the procedure precisely or the deadlines or timing. So I can only speak with expert authority to Michigan law relative to landlord-tenant.
Now you talked about making mistakes on a 7-day notice.
Yeah.
So there is a state form to fill out for that 7-day notice. I guess I'm struggling to see where they would make the mistakes on it. So
sure, and I'll turn to that. Okay, and we can cover that. There's a couple pages that I'm going to ask people to make sure that they, if they're doing their own forms, they should know where to find forms that are fillable and free, by the way, and are compliant with Michigan law. So let's, do you want to start, Reed, perhaps with the demand for possession? That's the situation where someone hasn't paid their rent and basically the landlord wants their rent money, but we'll give them an opportunity to stay if they pay.
yeah, so that's
I'm looking at that right now, and that is form number DC 100A.
Hey.
Right on. That's a demand for possession for non-payment of rent. That's the Michigan form. You can find this form, at least an attorney usually goes to, they Google Michigan S as in Sam, C as in Carl, A as in Adam, O as in Oliver. Michigan SCAO forms, demand for possession. Okay, and then they find this form. Okay, so you get to the form, and one of the two forms has at the bottom, I don't know if they can see this, but it says how to get legal advice. That's the one that gets mailed, and I'll talk to you about mailing and service in a moment, but that's the one that gets mailed to the tenant itself, not the form that says certificate of service. So sometimes people screw up on sending out the wrong notice. And if this comes up in a courtroom and you get a tenant-friendly judge, you could have a problem. So I'm just saying, and I'm reiterating, make sure that how to get legal advice, that notice is the one that gets mailed out to the tenant. A lot of mistakes, people don't add and all other occupants. Reed, do you put all other occupants on all of your notices?
Yeah.
Okay. Do you know why? I'm testing you.
This would be a guess, but I would assume because then the person who is there wouldn't be evicted. So you would kick the person out that you sent the notice to, but not the other people.
You're absolutely right. We don't know who's squatting on the car. We don't know if there's a boyfriend, girlfriend that moved in after the fact. All we have is the name of the person that's under lease. So we put all other occupants in there for a number of reasons. It covers pretty much any adult that might be there that we don't know about, because we might go through the entire eviction process, and if you don't put all other occupants on your notice itself, the judge will not give you the right to actually go forward and have a bailiff put out another adult occupant that has established residency in the apartment or home. So that's one of the big things, is that a lot of newbies, they neglect to, when they're addressing out their notice, they forget to put the name of the people that are under lease, and they forget to put in all other occupants. Okay, so that's an important one. One other thing is, the rent line item. There's a line here, a blank, where the person that's generating the notice has the opportunity of putting in the amount of money that is due. Now that money is only supposed to be the rent, okay? All the other charges like late fees that are due, utilities that are due, it's not going to kill your case, but it's better just to put the rent line item number down there, okay? That's a mistake that a lot of people make as well. If you have an LLC, make sure that you always sign the notice at the bottom next to your signature. Type out your name or write out your name for blank LLC, okay? I always want people to be able to preserve their LLC status as best they can. There's a lot of pitfalls in that. But always, when you're operating under an LLC, sign your name for, Acme LLC, whatever it is. So that's something that I would recommend whenever you sign off on your notices. Make sure that you're the representative of the LLC, because you get a personal injury lawyer and they're looking for anything that you did wrong to get through your LLC and maybe get at your personal assets.
And that's for all legal documents. Just
all legal documents.
Yeah, just so everybody knows it.
That I learned that one in law school, actually. That was like one of the first things that we learned, is that if you're setting up a corporate entity, and the whole purpose, frankly, of setting up the corporate entity was for taxation or for personal asset protection, there's certain things that you must adhere to maintain your LLC status, to maintain your protections. Signing as a representative of your company, things like keeping corporate minute books, doing proper authorizations, having an LLC operating agreement, basically don't commingle assets, don't have an extremely high level of personal management over the property yourself. There are so many reasons that one can get the corporate or LLC protection pierced through by a good attorney that's coming after you for like a personal injury or a mold related problem. So many ways that it can be done. That's why I put more stock in making sure that you are well insured as an investor, as opposed to focusing so much on the LLC. But going back to the whole item of LLC and signing, if you've set up the LLC, you might as well make sure that whenever you sign your name as a member of the LLC. Okay, we talked about mailing the correct notice. Here's a common mistake, whether or not we're dealing with a notice to quit or a demand for possession. A lot of investors try and be heroes or superstars by trying to hand deliver notices, the preliminary eviction notices, to their tenants. There's a number of reasons why you might not want to do that, and you just might want to take the easy route and putting a 50-cent stamp on there and just mailing the notice. If you try and personally deliver a notice to someone, sometimes just from the basic standpoint is they might not be a happy person to begin with, and you can get yourself into trouble. So why are you mixing it up trying to hand a notice to someone? I would say if you're going to hand notices to people, you just make sure that you're safe. That's all. If you just mail the notice to the tenants, then that covers everyone that's in the household, as opposed to if you hand it to someone, then that only covers that adult occupant when you hand the notice to someone. So that's why I always recommend, in lieu of actually going to someone's house, the rental property, and handing it to someone, you just drop it in the mail. Okay, that's truly the way to go. If you choose to send it certified mail, that's not an authorized way of serving it. Just make sure that you do it by regular mail. And then if you want to tape it to the door, that's fine. But the controlling method of service is going to be the mailing, in my opinion. That's what I always do. It keeps me living to see another day. I don't get in my tenants' faces about it. And I know that if I mail the notice, I don't even need proof that it was received. All I need to do is check off a box when I'm filing in court that says that I mailed it, and then we're good to go. So I stress mailing when it comes to getting those first notices out. Right, so that's demand for possession. Those are the easier forms, Reed, when you're doing a 7-day demand for possession notice. The more difficult one is the notice to quit.
Before we go into the notice to quit, I see a lot of people confused on the timeline. And again, this is just Michigan, but so that, the 7-day notice or demand for possession, when can you send that out?
Right. So when you send it out, the day that it hits your mailbox is the day that you put on your form and you sign it, okay? You can't actually file in court until 9 days later. I don't know if that's kind of where you're going with this whole thing. They call it a 7-day notice, meaning that under the black and white terms of the notice itself, it says that you have to pay within 7 days. That's why they call it a 7-day notice. But it really, when it comes to the standpoint of filing it in court, it's a 9-day notice, because the court allows for 1 extra day for mailing. And then there has to be the following day where it's mature to file in the courtroom. So that's the difference between 9 days versus 7 days. Was that the question that you were going after, Reed?
Well, so you can send that out. What I was suggesting, I was going to go through the whole timeline. So the rent's due on the 1st. The second day you can send the 7-day notice. And then,
okay.
I've always said on the 10th day, but you just said the 9th, you can then proceed. So what's the step after that?
Okay, actually, I like your line of questioning a little bit better, because I think that would be of more value to someone that's watching the podcast. Let's go through the actual timing of it and kind of parlay into the timing of like what a full-length eviction would take, okay? So let's start with the lease. The lease says, for instance, and I see this most commonly, rent is due on the 1st, but you shall have a 3 or a 5-day grace period, okay? Even though there's a grace period, you can issue the demand for possession the day after rent is due. I wouldn't do it because, you know, that'll just aggravate the tenant, but you're free to do it legally, even though there's a grace period. If rent is due on the 1st and there's a grace period until the 5th, you can actually mail a notice out on the 2nd. I tell all of my prospective tenants before I sign up with them, you know what? Yeah, I'm a landlord lawyer. You'll get a notice from me if you're a few days late, okay? But that doesn't mean I'm a bad guy. It's just to cover me. I don't want our lines of communication ever to fall by the wayside or for you to crawl underneath a rock. I want you to talk to me, okay? That's how I initially make my pitch for when I'm talking to a prospective tenant. But yeah, you can send this notice out anywhere from the 2nd to the 5th to the 9th. Whenever you want to send it out, it's up to you. You have to establish as a landlord and an investor what your tone is going to be with your tenant. I mean, if you're popping them with a demand for possession on day 2, there's nothing wrong with it. It's just you have to perceive how is this going to set the course moving forward for your landlord-tenant relationship. Mm-hmm. It's up to you. I mean, the investor knows that better than I do because the investor is going to be the one that is going to be dealing with the tenant more so than I am. Mm-hmm. So let's say you send it out, okay? Let's say that they're late on rent and you send it out, let's say on the 5th, okay? Then we have to wait the 9 days if you mail it out after the 5th to have an actionable case that you can use the notice to file in court with, okay? So now what are we at? We're now at day 9 days, the 5th. So we're now at the 14th of the month, right? Where the decision has to be made if they haven't paid, do we file in court or not? If you file in court and you get the court filing on the 15th or 16th of the month, the court will then set your first court date, all right? And that will happen within about 10 days. So now you're at day 25 of the month. At day 25, you have your court hearing, and if the other side doesn't show up, or if the other side agrees with you, they will get 10 days to cure whatever amount is due and owing. So now you're at day 35, all right? Before you can actually, if they completely screw you and don't pay you, go through the court hearing and they're still in the property, still haven't paid anything, it's actually at day 35 that you have to finalize the eviction process. And I'm talking about this timeline just very generally, okay? I mean, I'm saying day 35. It might move back or forth depending on how quickly you get your case scheduled, depending on whether or not they have asked for an attorney and put the case off by right for an extra 7 days. This is a target that moves. So I'm just talking about in the best case scenario, day 35, you'll have a judgment in hand from the judge that says they have to pay or move by that date. If they haven't paid or moved by that date, we have to follow the final step, which is an order of eviction. In fancy legal parlance, they call it a writ of restitution. But that happens at or about day 35. And then there might be some real delay in getting the bailiff to put someone out as quick as possible. I mean, as investors, we want to turn this property over and get it productive as soon as we can. So believe me, you and I want to get in there like as of yesterday. But if we have a judge's order that says that they're to move by the, whatever day it happens to be, let's say the 35th day in the process, then the bailiff themselves, your eviction is not the only eviction they're going to have on their desk. Yeah. So, it very well could be another 10 or 14 days even after that point to get someone out. So call it the best case scenario. I'd say that if a tenant really decides to stick it out, you're looking at about 35 to 45 days to finally getting a bailiff out there with an authorized judicial order to put someone's things to the curb. In Detroit, you have to have a dumpster put in the driveway, which is another $350. And you can't do anything if you're in Detroit as far as getting the bailiff out unless the dumpster's there. I think that's why we might have so many dumpster people on these respective real estate websites, is because, it's a very fertile and lucrative side to this business, especially when a particular city like Detroit requires that the dumpster has to be there.
Now, you mentioned on the court thing, I think it'd be worth mentioning. Now, if you are an LLC, you cannot represent yourself on that. Is that correct?
That's correct. That, believe me, that helped me and my fellow brother and sister lawyers when they started cracking down on this about 10 years ago. If you have an LLC, it's basically that you have established an entity, and you can't represent an entity because you have to be a lawyer to represent an entity. As a constitutional right, we can represent ourselves only if it's our own property. But if you have in your lease document or on your deed that this property was held by an LLC or the landlord is an LLC, if you think that you're going to have the ability to go into court and represent yourself in this landlord-tenant relationship eviction case, most judges will catch you on that now.
Yeah.
Some of the ones upstate, they still let it slide a little bit. And a lot of people are still getting away with it so long as the case doesn't go before the judge. You know, they file the papers on their own, even though it's an LLC. The court clerks don't catch the fact that you don't look like a lawyer. They don't question you whether or not you're a lawyer, and you file the case. And then if the tenant doesn't show up in court, many cases will just take the paperwork from whoever does appear in court, whether or not they're a lawyer or not. And so long as it doesn't go before the judge, oftentimes people still get away with representing themselves. They still try it. But I get a lot of calls from people that tried it and the judge caught them on it, in which case I have to step in and maybe even charge you a little bit more, because if you filed the case all wrong, I have to consider whether or not I'm going to have to correct it. So,
Yeah.
So at any rate, yeah, that started to be enforced, Reed, about 10 years ago. The law has been on the books for many years, but I started to see the judges really crack down on that whole thing about 10 years ago.
Yeah. So that's the timeline of the 7-day, which would be for non-payment.
Right.
And then the notice to quit is when we want them to remove when we want to physically
terminate the tenancy. We want to terminate the tenancy completely for some substantial reason in the lease that was breached. And I say in the lease because that's why it's important to have a good lease, is you have to have clauses that expressly set out what you expect your standard to be. Okay. If you have a good detailed lease, then you have a better chance of being successful on a termination case in court. And by the way, termination cases can also be, I alluded to this early on, if you're out of the term of the lease, or if there is no lease, then a notice to quit, a 30-day notice, would be the appropriate notice in a case like that. But on the process of the 30-day notice, that whole timeline that I told you about is delayed from the standpoint of we have to wait 32 days before we can file the case in court after issuing the notice to quit, because it's called a 30-day notice. So on the notice itself, there's a number of boxes, there's a number of lines. It's less intuitive than the demand for possession notice. So the 30-day notice basically means we got to wait 32 days before we can file the case in court after we've mailed it to the tenant. So that whole timeline that I was talking about of 45 to 60 days before you can get someone's things out, a 30-day notice is going to be longer than that, because you have to wait out that initial 30 days, not the 9 days that I first talked about, but the full 32 days. So that's the timing of the situation. It's a bitter pill to swallow to basically send someone a 30-day notice and understand that you can't accept any money while that 30-day notice is pending. Otherwise, you got to start the notice over again. And that's another thing that I think that a lot of new people to the eviction process don't understand. If you seek to terminate someone with a notice to quit, a 30-day notice, you cannot accept basically 1 penny of rent while that, or payments of any sort, without a clear understanding that the acceptance of payment does not stop the 30-day notice from moving forward into court. You are seeking to terminate the tenancy. So if you accept rent or any payment after you issue it, and it gets before the judge that you accepted a payment, the judge will say, I don't have jurisdiction. You have to redo your 30-day notice.
Can we dig deeper into that? So I want to clarify, on the 7-day notice, you can accept payment because you're not removing them. On the notice to quit, so there's different reasons you could do that. So if it's the end of the lease and you want to terminate them, but you're still going to collect that last month's rent, or am I incorrect on that?
You're incorrect. And you're incorrect on that. That can bog down the whole termination process. If you accept the last, what I try and do is I try and get the last payment of rent that I can get, and then I pop them with a 30-day notice right after. So that way you're not going through a period of time where you're going without rent and relying on, taking the money from the security deposit. That's the one bad thing about 30-day notices, especially at the end of a tenancy, is that conceivably there can be a period of time where the tenant is living for free and they're not leaving. But sometimes that's just the nature of the beast. You have to wait in that case to have the any money transferred out of the security deposit done after they truly vacate. It seems alien and not intuitive to a lot of people. There are certain clauses that you can put in a lease that will help you along with not having to serve a 30-day notice if the lease isn't renewable or if it doesn't continue on a month-to-month basis. If you have those clauses in the lease, then you have to issue the 30-day notice if money is accepted after the last day of the lease itself. It's confusing, and people get into a lot of trouble over this one, but that's the one downfall that I always have to counsel people on about issuing a 30-day notice, is the fact that they should probably time it such that they get some money and then they issue the 30-day notice. Because I, as an investor myself, who wants to go without a month's rent? But you also have to understand that the laws are set up such that they tried to create this so that there's no confusion about how acceptance of money will suggest to a tenant that they can stay longer. Doesn't make much sense, but it's just how the law works. There's a case called Forest Hills. I won't bore everyone and put them to sleep with starting to talk about precedent and things like that, but it's called the Forest Hills case.
We'll also put in the show notes, we'll put the link to the notice to quit.
Yeah, one thing that we can get in very briefly about filling out the notice to quit is the rules as far as all other occupants still are the same. On the notice to quit, you actually have a blank where you're supposed to fill in the date that they're supposed to be moving by. A lot of people make the mistake of just putting 30 days in there because they figure it's a 30-day notice. Because of the mailing and things I talked about, you have to count out and put a date in there that is truly 32 days after you signed off on it, okay? So I actually make my staff and whoever's doing these notices make sure that they count out 32 days and put 32 days on that blank that specifies the move out date. And again, the same concerns that I have about mailing out the right notice also apply to the notice to quit. The one that the landlord keeps for themselves says at the bottom, certificate of service. That's the one we retain. And the one that goes to the tenant is the copy of the notice that says how to get legal advice. The notice number for that, for the notice to quit, is DC 100C. So yeah, notices to quit lengthen the process by about 20 days. And you have to prove in court, in the most simple case, that they don't have a lease anymore, or they're out of the term of the lease, or if you've breached, or if they've breached the lease, you have to specify the lease provision that bans the breach, okay? And you have to prove that in court, and it has to be a substantial breach. It can't be something like they, you know what, they didn't trim the hedges, and it's in the lease. So, you know, I'm going to give them a 30-day lease. A judge is going to look at you and say, really? You know, and they're going to determine that that's not a substantial enough breach of the lease to force someone to move because they didn't trim the hedges. It has to be a substantial breach of the lease. And by the way, every lease should have something called a chronic late payer clause that authorizes termination. So if they have paid you late a number of times, like let's say 2 or 3 times, it should say in the lease that you have the right to terminate. If you're sick and tired of, frankly, dealing with late payments of rent, you have the right to terminate the lease with a 30-day notice to quit.
So moving on to, you talked about delivering of the notices. You and I have gone over this as well, but we'll kind of talk about electronic communications. Can you service those? Can you serve those with email or other methods?
Sure. This law changed, I think, about 5 or 6 years ago. I actually talked to the Free Press about it when it first came out, because there were situations where, because a law passed that said that we could serve electronic legal notices, that was a new law. Some people were looking to shame other tenants by posting it on their Facebook page and things like that. So Um, so long as you have an authority granted in your lease or a freestanding agreement that says that you have the right to serve all legal notices to the tenant by a certain means, and it can either be by text or by some other electronic service media. It can be by email, of course. You can have that and you can do it, but it has to be in your lease, or it has to be an agreement that authorizes you to have that right. And it also has to have a revocation clause in it that says that even though this authority is granted and agreed to have someone served electronically, it can be revoked by the tenant at any time. So absent having the agreement about electronic servicing spelled out in those terms, that clause will be determined to be ineffectual if you didn't at least have the agreement in there that the tenant can revoke at any time. So if you don't have that electronic notice authority in your lease with the right language, you might want to talk to me about it. I mean, you can find it. You don't have to talk to me about it, but just make sure that you have the revocation clause in there as well. It certainly is nice to have the ability to serve someone electronically rather than putting something in the mail. But all the mailing does is it delays conceivably your case moving forward for 2 days. But at least if you drop it in the mail, that you've complied with the law. And there's some solace in that, so that you're not wondering about, oh gosh, did they truly revoke my ability to communicate with them electronically? Oops, I forgot to put the authority in there where they can revoke the electronic servicing at any time. That's why I'm a big fan of just doing things by mail. But I'm also a fan of having an electronic form of communication that everyone can go to that outlines, the full history of the tenancy. So I like having the electronic service provisions in there, but I'll tell you something, when it comes down to, even with my properties, serving an eviction notice, the demand for possession of the notice to quit, I always do it by mail, even still.
Yeah, that makes sense. I mean, it's not like it's expensive to send them first class mail, like 50 cents or whatever, but
it's the manner of service that frankly judges are most comfortable with as far as seeing and administering.
Yeah. So what are so Michigan, do you consider Michigan a landlord friendly or a tenant friendly state, and why?
Yeah, well, I consider it it used to be pretty tenant friendly, but until every city in the world, in Michigan rather, started enacting municipal licensing statutes and things like that. And there's other courts that are definitely tenant friendly. I'd say that it's kind of neutral. If you go into certain courts, I guess it's okay for me to name these courts. I think that Hazel Park is tough. I know that Detroit can be tough, although it's gotten a little bit better. There's now 3 judges in Detroit. Lincoln Park's a little bit strange, but for various reasons. There's you can't make the broad brush that it's a overall Michigan landlord friendly or a tenant friendly state, because really it truly depends on whatever city that you're in. When a client comes to me and says, this is the property that I have and this is the problem that I'm having with the tenants, I know right off of the get-go, okay, well, this is a judge, this is a court system where the tenant is going to be given a lot of voice in that courtroom. And in that situation, if I have that knowledge as a lawyer, I have to then become a counselor and tell my client that, hey, you got a tough judge, or you got a judge that, because of these things, you might want to just have an understanding or a deal with the tenant, because if it gets before the judge, this can end up blowing up on you and might delay the proceedings. You have to know the court that you're in. I mean, if you were to run through, give me quick, fast fire names of cities, I can tell you right off the get-go which one is a landlord, tenant, or neutral, or tenant-friendly court.
Yeah, that may be an interesting list to have, but
maybe. You know what? My assistant kind of has a cheat sheet on that, because I kind of know them off the top of my head, but my assistant does the setup with cases about what they're particular about. Yeah. And yeah, that would be kind of interesting for me to talk about that. I would hate for some of my opinions, though, to get back to my good judges, though, in those courts, though.
Certainly be counterproductive on your part.
Right.
So you mentioned Detroit as one of the cities. So I know Detroit, as you mentioned before the call, has just started the Detroit's Fair Chance Housing Ordinance.
Yep.
So let's.
They started that on Saturday. And I must confess that as I was preparing for another presentation last week, I was thumbing through my resource documents, because sometimes I just need to see what the current state of the law is. And then I came across this one because a client had just recently sent me an email about, hey, Justin, how do I deal with this? This is, do I have to do things differently in Detroit? And I wasn't aware that this was passed until my client brought it up to me. And then I found out that it was passed just this last Saturday. So I'm going to hold this up. Hopefully people can see it. But basically, it's just the title of the document that is the Fair Housing Chance Ordinance in Detroit. So what it basically says, I already posted on this one, and it was a very lively conversation. Whenever I post something, I kind of like seeing just how it all goes, and I don't interject that much. But what this is all about is it essentially says that we can no longer ask in Detroit on our housing applications. Actually, we can ask. It's just that it puts us under heightened scrutiny. You can't put a box on there with a blank, essentially, that says that, have you ever been convicted of a felony or a misdemeanor? Okay, a lot of people like to know that information when they're doing tenant screening, right? I mean, I certainly would be interested in knowing what that's all about. The logic behind such an ordinance is debatable, but what it essentially is trying to do is the city council in Detroit is making it a criminal misdemeanor to ask the question about felonies or misdemeanor, because they have a feeling as though that it unlawfully discriminates against Detroiters that might otherwise have perhaps a greater impact or exposure to felonies or misdemeanors and therefore be refused housing. So I'm just mentioning it from the standpoint of, I don't know how this is going to work in the Detroit courts, but if you get a tenant that feels once again that they were unfairly denied housing, especially if it's a Detroit property, then if you have on your application felony or misdemeanor questions, it could get you into trouble. You could be subject to an investigation. Doesn't mean that you're going to be found guilty of discriminating against someone unlawfully, but the ordinance itself says that they don't want to see the application process done that way. So what this might have the effect of doing is landlords not being as upfront with tenants about what they're really looking for in a tenant. So, a tenant might pay an application fee, and, you're going to do a criminal or a criminal background check on them anyways. You're going to find out that they were involved in a certain type of crime or misdemeanor, and you're going to exclude them, where you could have just been right up front with them, say, hey, you know what, I don't want you in here if you've had a felony within the last 5 or 10 years. Maybe it's better to have the free exchange of communication with a prospective tenant, because what this is going to do is, if you don't ask that question, a lot of people are going to be excluded from housing anyways, and there's going to be a lot more application fees going into the pockets of landlords.
Yeah.
So there's exceptions to this. I'm not going to go into all the exceptions because, there's certainly some crimes like sex offenders and violent crimes that are permissible to exclude people if you don't want them, but then you have to give them a right to show rehabilitation. It's a crazy network of mess, I think, that what they've created in Detroit by enacting this. Even though the intention might be good, I have a feeling as though this is just going to really bog the courts down, and investors are not going to like having to answer these things. So probably the best measure, if you're really concerned about such a thing, is maybe don't ask that question overtly on your tenant application.
Yeah, so you're still doing the background checks, you're still getting the information, and you're still able to make the decision yes or no based on that?
Yeah, well, if you follow this ordinance as a guideline, you can make a decision based on felonies or misdemeanors, especially if they're the type of felonies or misdemeanors that are listed in this ordinance. like I mentioned one, like sex offenders, violent, I have to read through this, but violent crimes resulting in lifetime registry on sex offenders list, arson. It brings up a good question. Maybe if borrowing the exact language of this ordinance and asking questions precisely about, have you ever been convicted for arson? Have you ever been on the life registry on the sex offenders list? Have you ever been involved in a violent crime? Maybe if you're more specific and use the actual language itself from their ordinance, you might be able to solicit the response from the prospective tenant that you want in the application. But I'm not going to give that advice yet. I'm just saying maybe. My attitude is that we don't want to be bogged down with this at all. And so maybe we should just be avoiding the question completely, and then we're left to making our own decisions. I've defended a lot of people in fair housing related complaints, and oftentimes the worst case scenario that I see is they tell you to do better the next time and to enact policies to change your application, or to enact policies that prohibit unlawful discrimination. So even if you get a fair housing related complaint, usually even in the worst case scenario, you don't get hit in the wallet too much, so to speak. It's more like, what corrective measures are you going to undertake from here? Yeah. I can't make that broad brush claim for every fair housing related complaint, but based on what I'm seeing here, it just might be a good idea to keep that off your application.
Okay, well, that's definitely something to keep an eye on and see how the courts react and how it plays out, because it definitely has some positive and some negative sides on it, and depending on where you stand, you could have some pretty strong opinions about that. So
and they did, believe me, when I posted that one up, and there's a method to my madness always. I like a good popcorn show.
Yeah.
And sometimes I put this up there knowing exactly who the players are going to be that are going to be responding very critically about this thing. And then I know that there's a slew of other people that understand or sympathize with the whole objective of why these type of laws are starting to take effect.
Yeah, it seems like the wrong group for them, but it's okay.
Yeah, that's right. Believe me, I make more enemies on that group, I'll tell you, when I seem like a wet blanket, throwing a wet blanket on everything, saying, you better not do this, you better not do that. They think that I'm just drumming up business for myself. I don't care anymore. If it results in business to me, fine. If it doesn't, it doesn't. I just want to move on and just let people know constructively what they need to look out for. And if they run into a problem after doing some things themselves, I'm here for them if we work well together. But, I get a lot of people that I know will react negatively whenever I say don't do this or don't do that.
Yeah, well, I got two more hot button topics. Definitely there could be some controversy. So the first one is support animals. So where is that law going? It seems like it's going much favorable into the support animals. Yeah. And it also doesn't seem like there's a lot of proof burden on the person having the support animal.
There's not. Now there's some things that you can do, but let's talk about the categories of these types of animals. And I haven't heard one time, Reed, between you and I talking, that you call these animals a pet, which is
I'm very careful of that. Yeah,
we're going to be careful about that. So let's talk about animals first. In the most broad, encompassing sense, we call them service animals, we call them assistive animals. Okay, assistive animals might comprise of service animals, where animals that you have someone that has a sight problem and that they're a seeing eye dog. Okay, that's a service animal. There's other classes of animals called emotional support animals. Okay, that's the most gray area that we're seeing is the emotional support animal. So let's say you really don't want pets in your unit, but someone comes to you and shakes your hand and it all seems well and good and everything, and you approve them, and then they produce a note and say, hey, I have Fluffy here, who's a emotional support animal, and here's my note. We're restricted, unfortunately, of playing too much detective on people that produce such a note, okay? Because we get into further problems if we try and get into person's medical records or have them describe a long length of history of their problems. We don't want to ask those questions because then we open ourselves up to other types of claims. But relative to the service animal, you can actually require documentation from a certain type of medical professional. Okay, you know, having it done by a secretary at a doctor's office is not going to cut it. If they're a psychologist or a psychiatrist or a licensed mental health professional, and they have an acronym for that, but it's licensed mental health professional. If they're one of those and they give you a dated notice that says, or a letter that says that this is a support animal, and they are within the state of Michigan, that is all the proof that someone needs. So let's flip that a little bit. If the letter is from an agency that's outside of the state, or if it includes someone that is not a treating medical professional that's authorized to diagnose this sort of thing or to treat this sort of thing, then you can actually reject the proof. You do so at your own risk, but you can reject the proof because there turned out to be this cottage industry, and you can find them online where you can get your ESA, your emotional support animal certification, by contacting us, paying us our $120, and then we'll write the letter to whatever airline or whatever landlord or whatever employer you have. Mm-hmm. And you'll get a letter in your hand, and that'll be your ticket to getting your pet in or your service animal in. Okay. But if you see that it's from an out-of-state entity, then that's not going to be good enough. So that's kind of a way of checking whether or not the whole efficacy of whether or not someone has the right documentation in order. You can't charge an extra pet fee if you find out that it's a service animal. Okay, it's kind of like enforcement agencies of civil rights will look at you charging someone for a service animal, not unlike you charging someone for having a wheelchair because they might mess up your baseboards more. Mm-hmm. Okay, so if you have a pet fee, you can't charge that if it's a service animal. So there's things that seem commonsensical to a lot of people that you have to be careful about when you're talking about fair housing and service animals. So that's a real hot button issue because even I had a couple of people with service animals come in on like 3 out of the last 4 of my rentals. So, I don't act as detective. I just, you win some, you lose some, but just be careful about excluding service animals. Don't be a hero and don't try and, be, a private investigator and try and shoot holes through someone's proof. You just might have to deal with it. Now, sometimes there's dangerous animal legislations and ordinances in different cities. I love pit bulls. Okay, I have pit bulls. Very sweet animals. Don't get me going if they're trained right. But there are some cities that have dangerous breed animal ordinances, and sometimes your insurance will give you trouble about certain breeds of animals that are brought in. That's a whole other 30-minute conversation, Reed, that I'm not going to get into.
Yeah.
We can cover that some other time if you want.
Well, that's good. I just kind of wanted to get your brief thought, and those are good. So the last hot button topic would be, and this one came up with because you mentioned it earlier, but was marijuana growing, and the laws of Michigan and many states are changing, and many landlords are uncomfortable with those type of activities in their house. Right. So what are your thoughts on where this is going, and what action should people take?
Right. It's kind of strange because once in Michigan we had the approval for recreational use over and above medical use, I got a little bit less concerned about how the law was operating in Michigan, about what we can exclude and what we can include. So in Michigan, you can exclude smoking of whatever, from your property. You can do that. And you're not necessarily discriminating against anyone unlawfully because they have a medical green card. Because frankly, if someone has their green card, they can still always smoke outside. So you can restrict smoking inside the unit. You can exclude growing from your unit because that adds moisture, right? That has a harsher effect on the leasehold itself. So, you know, if you have a growing situation, you can actually prohibit that type of thing as well. And now, because it's recreationally available, there's an argument to be made that you don't have to grow, right?
Yeah.
So you know, it's growing. I mean, I guess if you grow, I'm not into this line of business, by the way, but I guess if you grow, there's some advantages to that. But if you're a caregiver, but I think that you have no problem if you have a lease provision that excludes smoking in your unit and excludes growing in your unit.
Well, it seemed like maybe an easier question or easier answer than I thought, so that's good.
Yeah.
Well, Justin, we've definitely extended this longer than I anticipated, but it was only due to some amazing conversation. So I'm glad we were able to provide all that. So how can people get a hold of you if they want to look into your services in Metro Detroit, and what is your service area as well?
Right. I like to travel too, but as I say, I'm only licensed in the state of Michigan, but my primary service area is Wayne County, Oakland, and Macomb. But sometimes I like a change of scenery too. And if I have to travel up to Traverse City, I'm not opposed to that at any time at all. But I cover all the state of Michigan. And you can find me, my business, landlord-lawyer.com. You can find me on the web. My email address is michiganeviction@aol.com. Don't laugh at me, everybody. I'm an old guy. I still have the same AOL account that I started with long ago, but you can call me 248-398-9903, thelandlordlawyer.com, or send me an email at michiganeviction@aol.com.
Awesome. Well, that was very good. And I appreciate everybody for listening. And Justin, thanks for coming.
All right. Thank you for that.
All
See you,
right.
everyone.